All right, let's jump straight into this explainer. Today, we're dissecting a totally wild, highly dramatic divorce case study, but we're doing it strictly through the professional lens of modern family law, digital evidence, and mediation. So if you're a law student out there studying divorce ethics, consider this your cautionary lecture. We're looking at a guy named David. He finds out his wife, Sarah, is having an affair with his best friend, Brandon. Ouch, right? But instead of pulling them aside for a private confrontation, David orchestrated this meticulously planned public exposure. We're going to neutrally analyze the concrete legal implications of what David did and see exactly how modern surveillance is completely shaping courtroom outcomes.
To keep things organized, our agenda today breaks this complex case down into 5 clinical chapters: digital evidence, public exposure, asset distribution, custody and impact, and finally, the ethics of shaming. Let's get right into it.
Okay, Chapter 1, Digital Evidence and Surveillance and the Admissibility of Private Data.
Let's trace how this escalated, because David didn't just confront Sarah. Actually, scratch that. He completely bypassed the emotional confrontation and went straight for hard data. On days 1 through 3, he installed the GPS tracking app on his wife's phone, and he started logging these exact 2-hour daily visits to a local hotel. By week 2, he realized that location data alone might not be enough to prove infidelity in a courtroom, so he hired a private investigator. Then, by week 3, he had actually intercepted digital communications and future planning documents. He essentially built this undeniable chronological case file before the opposing party even had a clue they were being investigated.
And we aren't just talking about hearsay here. We are looking at a literal mountain of irrefutable digital evidence that ultimately became the absolute foundation of the court's final ruling. We're talking GPS patterns, time-stamped PI photographs of them interacting in the hotel lobby, and, most critically for the legal outcome, intercepted text messages proving Sarah and Brandon were actively planning to leave their families. You know, in family court, privately obtained surveillance can sometimes walk a really fine line when it comes to admissibility and privacy laws. But professional PI documentation combined with legally accessible text records, that often becomes the linchpin in proving fault or intent.
Moving right along to Chapter 2, the Public Exposure Strategy and Maximizing Social Impact. 150. That is the exact number of guests at David and Sarah's 11th anniversary party. And this was the exact venue David chose to publicly expose the affair. He actually coordinated with the event's videographer to splice the private investigator's photos into this romantic photo montage. So 13 minutes into a video celebrating their marriage, right in front of 150 colleagues, friends, and family members, the undeniable photographic evidence of the betrayal was broadcast on a massive screen. No way to hide from that.
There is a massive contrast here between standard legal practices and what David actually did. Usually as mediators, we push for standard, non-confrontational mediation. We want private negotiations, we want to minimize the social fallout, and we prioritize a calm, collaborative asset division to protect everyone's professional reputations. But David? He went with strategic public exposure. He opted for maximum social destruction, using a 13-minute video to corner them, followed by an immediate unilateral withdrawal from the marriage. It is a high-risk, scorched-earth tactic for sure. And right after the video ended, David literally grabbed the mic and delivered this exact speech. He said, "I have hired a private investigator. I have documented everything. I have provided all evidence to my lawyer. I will be filing for divorce tomorrow morning." Notice the incredibly clinical legal language he's using in such a highly emotional setting? In one swift motion, he transitioned the dispute from a private marital issue into an irreversible public spectacle and a formal legal declaration.
Let's get into Chapter 3, Asset Distribution and Court Rulings.
Now, you might be wondering how the judge reacted to all of this. Well, it all comes down to the legal concept of marital fraud. This is the act of hiding, transferring, or dissipating marital assets to fund a secret affair. The judge in this case was not sympathetic to Sarah at all, strictly because her actions legally constituted this fraud. The digital evidence proved she was actively using shared marital funds for hotel rooms, dinners, and planning to facilitate her infidelity.
Because of that undeniable fraud and the overwhelming digital evidence that totally removed any he said, she said ambiguity, the judge actually deviated from the standard 50-50 split we usually see in no-fault cases. The court awarded David a 55% majority of the assets. That undeniable surveillance trail hit Sarah directly in her financial standing.
The legal fallout here was just devastating for the offending parties, and it really shows how digital evidence paralyzed Sarah and Brandon's ability to negotiate favorable settlements. Sarah tried to claim spousal support and half the assets, but she was denied support entirely in order to pay child support. And Brandon's wife, Lisa? Well, she was sitting right there in the audience during the public exposure. She immediately filed for divorce as well, winning primary custody of her 3 kids and substantial support. The sheer weight of that prepared evidence completely stripped Sarah and Brandon of any legal leverage.
Okay, Chapter 4, Custody and Psychological Impact, which is really about the collateral damage.
If we put our family law mediator hats back on for a second, the custody outcomes are really fascinating. The court heavily favored the betrayed spouses. David won primary custody of his 12-year-old daughter Emma and his 9-year-old son Jake. Lisa won primary custody of her 3 children in a new town. Meanwhile, Sarah and Brandon were relegated to every other weekend visitation. And this wasn't just the court punishing them for cheating. Family courts prioritize the stability and best interests of the child. The documented evidence that Sarah and Brandon were actively and secretly planning to abandon their current family structures proved to the court that they were simply the less stable custodial options.
But guys, we really have to look critically at David's strategy here. We have to contrast the parents' intense focus on public revenge, legal battles, and social destruction with the incredibly heavy psychological burden placed on the children. These kids didn't just experience a typical divorce. They were forced to process their family's destruction in the public eye. Their parents became community gossip literally overnight. As mediators, we always warn clients that prioritizing maximum humiliation for your spouse almost always inflicts unearned trauma directly onto your kids. Even though the children in this case study have reportedly adjusted and forgiven their mother over the years, the emotional scars are real. The lasting emotional consequence is a permanent shift in familial loyalty. They experience a profound loss of innocent trust. As future lawyers or mediators, you have to remember that when a client chooses the path of public destruction, the children are the ones who have to navigate that social fallout in their schools and social circles for years to come.
Finally, Chapter 5, the ethics of public shaming and its long-term consequences.
Outside the courtroom, the public shaming completely decimated Sarah and Brandon's long-term professional and social reputations. Because the exposure happened right in front of 150 mutual friends and colleagues, the narrative couldn't be spun. They lost long-standing friendships, their professional relationships were strained, and they were permanently labeled as a cautionary tale by their community. It just proves that in cases of extreme public exposure, the harshest, most lasting penalties are often dealt by the community, not the judge.
When you break down David's strategy of truth, it is highly calculated. He bypassed an emotional confrontation for clinical execution. Emotionally detach, install surveillance, consolidate proof, pick a public venue, and present the unspun truth. It really highlights the massive, long-term impact that indisputable digital evidence has on modern court decisions. It gave him total control over the legal narrative, the financial outcome, and his personal vindication.
So, to wrap up this explainer, I want to leave you with a final, provocative thought for your own legal and ethical evaluation. We've clearly seen the undeniable legal effectiveness of David's masterclass in gathering evidence and executing a public exposure. But as professionals navigating the incredibly sensitive terrain of family law, you have to ask yourself, was this truly justice, or did the collateral damage to the children and the community completely outweigh the legal victory? Think about how you would advise a client sitting in your office in this exact scenario. Thanks for joining me today, and keep questioning that balance between legal strategy and human ethics.